following grounds. One, that the defendant objector is not juristic persons. And two, that the claim before the court constitutes misjoinder of parties. The particulars of objection includes that there is no juristic entity known as the Board of Trustees of Evangelical Church winning all. Two, that the claimant's claims are separate from each other. Accompanying the notice of preliminary objection is a 7-paragraph affidavit and written address. I've reduced the argument in support of same into the body of this judgment. The claimant also filed a 13-paragraph counter affidavit and written address. I have equally reduced the argument in response into the body of this judgment. Also filed by the defendant is a statement of defense, and it averred that in line with the condition of service, a new employee is usually confirmed after 2 years where there is nothing withholding such confirmation. It averred for that the claimants were issued with queries severally during their course of employment. And while it is true that it reported that claimants through the police, just a minute, that he reported claimants to the police, it is not true that it was after their dismissal from the service of the defendant and the claimants were not arrested, but rather invited by the area commander who sought to settle the matter. The defendant went further to state that when the secretaries and treasurers of the church made statement that did not give the monies to the claimants and that the monies were still with the churches as they were yet to pay the assessment given to their churches, the police said they could not hold the claimant based on the evidence given. It continued that the claimants were the head of the churches concerned, which for a period of 2 years before then did not remit any of the statutory dues, which are for the operations and payment of the assessment of salaries and other emoluments of their pastors, which are usually paid to the DCC office before they are remitted to the pastors concerned. The defendant also averred that it has not defamed the claimants as it was within its right to report to the police and did not make any publication of a complaint to any other body. It also averred that it took the necessary procedure to ensure that the claimants adhered to the defendant rules to enable them to continue their employment with the defendant, but the recalcitrant, which led to their dismissal, but they were recalcitrant, which led to their dismissal. It is also averred by the defendant bylaws and review condition of service, the employees are liable to intra and intra-district church council transfer, and are subject to that. Claimants were informed of their transfers, and when they refused to go on the transfer, the MOPA DCC, just a minute. The MOPA DCC issued warning letters to them, and they were subsequently asked to report at their stations to the General Secretary of the defendant. They were also invited to report to the headquarters in Jos, but also failed to honor the invitation. Neither did they collect the said invitation letter. The defendant asked them to show cause why disciplinary action should not be taken against them, but they yet again remained disobedient. Hence, their case was reported at the General Church Council, and their dismissal was approved and communicated to the MOPA DCC. It further averred that since the claimants refused to collect the said dismissal letter, went ahead to publish it in the Tribune newspaper of 14 January 2016. It stated that the claimants were given an opportunity to write an apology letter and get reinstated, but they refused and rather absconded. At the close of pleadings, parties by their respective counsel informed the court of their desire to adopt the argument on record procedure, which is pursuant to Order 38 Rule 33 of the National Industrial Court Civil Procedure Rules 2017. By this special procedure, parties have dispensed with the need for oral hearing, and the case is to be tried on record by considering the pleadings of the parties and documents front-loaded. Subsequently, parties were ordered to file their respective written addresses. And as it is customary to do this in this special procedure, claimants filed their final written addresses first. I've reduced the argument also into the body of this judgment. The defendants filed their final written address in response, and the claimant filed a reply on point of law. I've reduced all that into the body of this judgment, so I'll go straight and read out the decision of the court. I've carefully perused the originating process together with its accompanying processes, the notice of preliminary objection filed by the defendant, together with the defense, the reply to statement of defense by the claimant, final written addresses of parties, and reply on point of law by the claimants. I am of the firm view that the issues, the determination of which will do justice to this case are: one, whether this action as presently constituted is competent against the defendant, and two, whether claimants have proven their case to entitle them to the relief sought. Respecting issue one, it is the position of the defendant, read its notice of preliminary objection, that the defendant is not a juristic personality, and as such, its name should be struck out. I'm mindful of the submission of learned counsel on behalf of the claimants in paragraphs 1.2 to 1.4 of the written address in opposition to the notice of preliminary objection, that the objection of the defendant is incompetent since the defendant's motion for extension of time to regularize only relates to the memorandum of conditional appearance alone and does not include the notice of preliminary objection, which was also filed out of time. He argued that since the defendant did not seek leave to file the notice of preliminary objection out of time in line with the rules of court, same is incompetent before the court. He equally maintained that the defendant is not even before the court because the application to regularize the memo of conditional appearance was not even moved by the defendant. It is noted that on the 20th of October 2021, when the defendant appeared in this court and informed the court of the fact that they have entered a conditional appearance and filed a notice of preliminary objection, the application for extension of time to regularize the memorandum of conditional appearance was not moved. On the said date, the defendant moved its notice of preliminary objection without any form of complaints from the learned counsel on behalf of the claimants, and the court ordered that the application will be considered together with the main suit. It is true that the application to regularize the memorandum of appearance, which though was not moved, was only to regularize the memorandum of conditional appearance and not the notice of preliminary objection, which was filed on the same date with it. This is in fact in contravention of the rules. This is in fact in contravention of the rules of court, which ought to be obeyed. However, I am mindful of the decision of the Supreme Court in the notorious case of UTC Nigeria Limited versus Pompamote, citation captured, where it was held, I quote, "The rules of procedure are made for the convenience and orderly hearing of cases in court. They are made to help the cause of justice and not to defeat justice. The rules are therefore aids to the court and not masters of the court. For the courts to read the rules in the absolute without recourse to the justice of the cause will be making the court slavish to the rules. Slavish to the rules. This certainly is not the reason deter of the rules of court, unquote." See also the case of Duke and Akwabuyo, LG, citation captured. Thus, rules of court are not meant to enable a party to score a cheap goal based on mere technicality, and as such, the court in the quest of doing substantial justice may depart from the strict adherence with the rules of the court. See the case of Shosanya and Onadeko, citation captured. The case of Ineji and Chuku, citation also captured. In my view, the objection of learned claimant counsel to the competence of the notice of preliminary objection based on the above grounds earlier stated is nothing more than reliance on crass and crude technicality. In fact, it is my view that the appearance of the defendant in this case is competent, notwithstanding that the motion to regularize the memorandum of conditional appearance filed out of time was not moved. In support of this view, I call in aid the dictum of Onoge GSC, CJ, and retire in the case of AB and COP, citation captured, where he stated thus, and I quote, "The word quote and unquote appearance is defined as a coming into court as a party or interested person, or as a lawyer on behalf of a party or interested person, especially a defendant's act of taking part in a lawsuit, whether by formally participating in it or by an answer demurrer or motion, or by taking post-judgment steps in the lawsuit in either the trial court or on an appellate court. An appearance can either be personal by the party to the action or appeal, or through his legal practitioner. The word signifies or designates the express or overt act by which a party against whom an action has been instituted or who seeks redress from the court of law submits himself to the jurisdiction of the court. The act of appearing in court may be expressly made by formal memorandum of appearance or to physically appear and make oral declaration or statement to that effect, or may be implied from some act done with the intention of appearing and submitting to the jurisdiction of the court, unquote. See also the cases of Birunke and MTN citation captured. Thus, the mere fact that learned counsel on behalf of a defendant appeared in person on the 20th of October 2021 to move the notice of preliminary objection has cured whatever defect in the memorandum of conditional appearance. Learned counsel on behalf of the claimants needs to be reminded that the courts are in the era of doing substantial justice and have shifted focus from mere technicalities. See the cases of Ecobank and Siloam Global Service Limited, citation captured, the case of Jait versus Okulo, citation captured, registered trustees of airline operators of Nigeria versus Nigerian Airspace Management Agency, citation provided. The mere fact that the motion to regularize the memorandum of appearance was not moved, and the fact that the said motion to regularize does not include the notice of preliminary objection will not bar this court from considering the notice of preliminary objection, which borders on the jurisdiction of this court, that can be raised at any stage, and especially where the claimant responded to the same notice of preliminary objection by filing a counter affidavit and written address in the position to same without any objection. Thus, this court is inclined towards considering the notice of preliminary objection. To my mind, to do otherwise marks of resurrecting the antis of technicality that is long buried in the bowel of our legal system. Accordingly, the objection of claimant's counsel to the competence of the notice of preliminary objection is hereby discountenanced. And it is also noteworthy of the fact that by the same rules of this court, or the 5, allows this court to depart from the strict rules of evidence to do justice in every case. So by order 5 of the rules of this course, I depart from the strict provisions of these rules and to ensure that justice is done in this matter. The question of juristic personality is so important in the sense that it touches on the jurisdiction and competence of the court to entertain a case, and as such can be raised at any stage. See the cases of the local government and Akwa Ibom state government, citation captured, social political research development and Minister of FCT, citation captured, Bank of Baroda and Yalabani Limited, citation captured. It is the law that juristic personality can only be donated by enabling law. If the enabling law provides a name by which a party should be sued, the party will be sued in that name. See the case of Abubakar and Yaradua Supra. The law attributes or ascribes juristic personality to natural and artificial persons. See the case of Dairo and registered trustees, TAD Lagos Supra. The law is settled that only a juristic person can sue and be sued. The pertinent question at this stage is, considering the facts and circumstances of this case, can it be said that the defendant is not a juristic person? In my view, the defendant is a juristic person, and if at all there is a mistake in stating its name, it was only sued in the wrong name, which makes it a misnomer, and I will proceed to explain why. From the facts of the case, particularly looking at the pleadings of parties, it is clear that claimants were known to the defendant and had a relationship which led to the dispute in this case. It is equally clear that the defendant is a faith-based organization. or through the affidavit in support of a notice of preliminary objection deposed to by one Monday Santawa, it was not stated that the entity intended to be sued does not exist. All that was stated therein was that there was no entity known by the name Board of Trustees of Evangelical Church Winning All. In fact, in paragraph 3 and 3A of the said affidavit, the correct name of the defendant seems to be, quote, the Registered Trustees of Evangelical Church Winning All, unquote. I say so in view of the fact that the deponent in paragraph 3 of the affidavit made mention of the fact that he was informed of the facts contained therein by the, quote, legal officer to the Registered Trustees of Evangelical Church Winning All, unquote. In fact, he deposed further in paragraph 3A of the same affidavit that the defendant was served with the originating process through one Mrs. Janet Joseph, who conveyed the same to the legal officer in her capacity as the legal officer to the Registered Trustees of Evangelical Church Winning All. Besides, Exhibit A, attached to the affidavit in support of the notice of preliminary objection, which is the certificate of incorporation, shows that the trustees of Evangelical Church Winning All were registered by Companies and Allied Matters Act 1990, pursuant to its section 682, subsection 3. In fact, the names of the trustees were aptly captured in the said certificate of registration. It is therefore clear beyond doubt that there is an entity existing as trustees of the Evangelical Church Winning All. It is juristic personality and has been clearly shown by the production of a certificate of incorporation. See the case of Daira and Registered Trustees, Supra, TAD Lagos, Supra, G&T Investment Limited and Wheat and Bush Limited citation captured. The case of ACB and Emos Trade Limited citation also captured. The problem seems to be that the name to be sued was not gotten correctly in the sense that it was supposed to be, quote, the Registered Trustees of Evangelical Church Winning All, unquote, which is normal way incorporated trustees are sued instead of Board of Trustees and Evangelical Church Winning All sued in this case. It is the position of the law that where there is a mistake with regards to the name of a litigant in an action, such a mistake is described as a misnomer. There is a misdescription or wrong use of a name. In the case of a Mespo, J Continental Limited and Corona Shifa, Gel Shaft and others citation captured. The Apex Court per Mukhtar GSC held those, and I quote, a crucial factor in determining whether what happened was a misnomer or not is whether there is an existing entity which has been given a wrong name, such wrong name not being the name of another entity, unquote. Thus, a misnomer occurs where the entity suing or intended to be sued exists, but a wrong name is used to describe the identity of a particular party to the litigation, giving a wrong name to the right person, and other of the above decisions which are adopted as mine Excuse me, can you still hear me? Can you hear me?
No, my lord.
So now you can hear me. You can hear me now.
Yes, my lord.
Wow, which part did I go off? Can you remember? The name. It's normal. Okay. So I'll continue from there.
Yes.
Thus, a misnomer occurs where the entity suing or intended to be sued exists, but a wrong name is used to describe that entity. Therefore, it is a mistake as to the name and not as to the identity of the particular party to litigation. Put differently, a misnomer lies in mistakenly giving a wrong name to the right person and the person intended to be sued. See the cases of Njoku and others versus Owune Lega citation captured, MTN Nigeria citation captured. In the light of the above decisions, which are adopted as mine, and considering the fact of the notice of preliminary objection, I ask, was it misled that it was the right entity to be sued and did in fact sued? In fact, from the document matters which is unless the counter preliminary objection. It is to recover possession from the second before a district court in Kogi State. The said name, which it is now challenged in the case of registered trustees of Airline Operators of Nigeria and Nigeria Airspace Management, SUPRA, The internet is having hiccups, so I've changed the internet I'm using now. I hope this one will be better. Can you hear me?
Yes.
Very. So let me continue from where I stopped. I was about to quote Honorable Justice Okoro GSC in the case of registered trustees of airline operators of Nigeria and Nigeria Airspace Management. So I'll go ahead and quote him. This court held that a misnomer occurs when the correct person is brought to court in the wrong name. In the instant case, the appellant actually initiated the suit giving birth to this appeal at the High Court, with the name he is now abandoning. He did not contest that name at the court below. He has not shown how he has been affected by the use of that name. Let me state emphatically here that when both parties are quite familiar with the entity envisaged in the writ of summons and could not have been misled or have any real doubt or misgiving as to the identity of a person suing or being sued, then there can be no problem of mistaken identity to justify a striking out of the action. A misnomer that will vitiate the proceedings will be such that will cause reasonable doubt as to the identity of a person intending to sue or be sued, unquote. The name used in suing the defendant in this case was known to parties before the present suit. In fact, the defendant had used the name to sue the second claimant, as I've stated earlier, before now, and it has not told this court how the use of that name by the claimants has led itself out to be known by the claim. Let me take that again. In fact, the defendant had used the name to sue the second claimant before now, and it has not told this court how the use of that name by the claimant has affected him. And the defendant has actually held itself out to be known. Let me take that again. In fact, the defendant had used the name to sue the second claimant before now, and it has not told this court how the use of that name by the claimant and has held itself out to be known has affected it. It is too late for the defendant to now wake up to be challenging the same name it has used in previous proceeding between itself and the parties. Besides, the courts have departed the era of deciding cases on technicalities, as I've stated earlier in this judgment, rather than on the merit, as the aim of courts now is to do substantial justice. The defendant, having used the name before in previous proceeding, cannot at this stage be challenging the name under which it was sued, and therefore discountenance the objection on the juristic personality of the defendants. It is equally the position of the defendant via the notice of preliminary objection that the claimant's claims are separate from each other. In fact, in the affidavit in support of the notice of preliminary objection, it was deposed that the claimants are 3 in number and the claimants have separate claims against the defendant and that each claim is personal to the claimant. However, it is worthy of note that part of the questions formulated for determination of the written address in support of the notice of preliminary objection is that the case of the claimants constitute misjoinder of parties. Although learned counsel on behalf of the defendant did not offer any argument in support of this in his written address in support of the notice of preliminary objection, I am mindful of the submission of counsel on behalf of the claimants in his reply on point of law to the final written address that the defendant's failure to advance arguments in support of this leg of the objection is tantamount to abandoning the said objection. The law is beyond arguments that failure to offer arguments in support of a preliminary objection will be deemed as abandonment of a preliminary objection. See the case of Onamade and ACB Limited citation captured, the case of Ajibade and Pedro citation also captured. Thus, the most reasonable thing to do in this instance is to deem this issue in the said preliminary objection abandoned. Assuming arguments were even canvassed in support of the said objection, can same be sustained in view of the recent judicial authority and in view of the facts and circumstances of this case? In the case of CBN and Adedeji, citation captured, the Supreme Court was of the view that employees who might have had separate contracts of employment with a cross-respondent could sue together, since it is their contention that the rationalization exercise was done in a blanket manner and across board, and therefore the effect of the exercise on all of them was the same. Thus, their common grievance or interest is therefore their redundancy and the restoration of their job, and as such, have common interest to enable them sue together. In the instant case, it is the case of the claimants, via their statement of facts, that the allegations leading to the dispute in this case were made against them by Mokwa District Council, and which allegations led to their investigation by the police and subsequent dismissal from employment and the stoppage of their salaries without following the laid down procedures and the equal reviewed condition of service. Their common grievance or interest is therefore the alleged dismissal and stoppage of their salaries and failure to follow the laid down procedure, and as such can maintain this action together as they did. Besides, the position of the law is clear that misjoinder will not defeat an action unless there is a miscarriage of justice. See the case of Olorunleke and others versus AfroWorks Nigeria Limited and others, citation captured. The case of Lokoja and Nigeria Construction and Furniture Company Limited, citation equally captured. See also Order 13, Rule 1 of the Rules of this Court, 2017. As such, the objection, even if argued, cannot terminate this action and is thus inconsequential. Accordingly, issue 1 is resolved against the defendants and in favor of the claimants. On issue 2, let me first state that the general usual practice is for a claimant to repeat the relief sought in the general form of complaint in the statement of facts. However, in the instance suit, while claimants sought 6 reliefs in the general form of complaint, they sought 7 reliefs in the statement of facts. Which means that they introduce a new relief to the statement of facts. However, apart from the fact that a new relief was introduced in the statement of facts, the way the reliefs in the general form of complaint were even couched was different entirely from the way the ones in the statement of facts were couched. The law is settled beyond peradventure that a statement of claim supersedes the writ of summons. Herein, we call it here general form of complaint, and as such, any claim or relief contained in the statement of fact, in the writ of summons, which is not repeated or reproduced in the statement of claim, is deemed abandoned. Thus, it is the reliefs as contained in the statement of claim, herein a statement of facts, that will be considered where there is a difference between the relief sought in the writ and the statement of claim. See the cases of Zenith Bank PLC and Idigbe, citation captured, Izemwa and Oko and others, citation provided, Elf Nigeria Limited and Silo, citation captured, Enigbokun and American International Insurance Company Nigeria Limited, citation captured. In view of the above, I will consider the reliefs as sought in paragraph 34 of the statement of facts. It is the position of learned counsel on behalf of the defendant in his final written address that this court does not have jurisdiction over the defamation aspect of the case. He placed heavy reliance on the case of Bisong and Unical Supra. Learned counsel on behalf of the claimants in his reply on point of law urged the court to hold that it has jurisdiction on defamation because the facts of the cases of Bisong and Unical Supra and Adama Beverages and Akam Supra are distinguishable from the facts of the case at hand. Section 254C1A of the Constitution of the Federal Republic of Nigeria, 1999, as amended, hereafter referred to as the Constitution, provides those, and I quote, notwithstanding the provisions of subsections 252, 257, 272, and anything contained in the Constitution, and in addition to such other jurisdiction as may be conferred upon it by an act of the National Assembly, the National Industrial Court shall have and exercise jurisdiction to the exclusion of any other court in civil cases and matters, A, relating to or connected with any labor, employment, trade unions, industrial relations, and matters arising from workplace, the condition of service, including health, safety, welfare, or labor, employee, worker, and matters incidental thereto or connected therewith, unquote. It has been argued by learned counsel on behalf of the claimants in the final written address that this court does have jurisdiction over the part of the claim that deals with defamation because it happened in the workplace of the parties and it is a matter closely related to labor and employment matter between the parties. He maintained that defamation is not only ancillary, but within and forms part of what happened during the employment relationship between parties, and as such cannot be completely removed from the jurisdiction of the court. I am of the view that looking at it literally, that may be so, that this court has jurisdiction over matters arising out of workplace or incidental thereto. However, the Court of Appeal, which is superior in status to this court, Obaseki Adejuma JCA, had, in the case of Olushola and another versus Andrew, citation captured, interpreted the meaning of the phrases, quote and unquote, matters arising from workplace, quote, matters incidental thereto, unquote, quote, or connected therewith, unquote, using section 254C1A of the Constitution in relation to the jurisdiction of this court does, and I quote, to interpret the phrases matters arising from workplace, matters incidental thereto, and or connected therewith, to mean any matter arising from the workplace or incidental to the workplace or connected to the workplace can only be litigated upon at the National Industrial Court is a profligate interpretation and negate the principle of main claim determining the jurisdiction of the court. This will invariably vest the National Industrial Court with a very wide and almost limitless exclusive jurisdiction in respect of civil matters that arise from the workplace within any claim which are ancillary and stand on determination of the main claim, unquote. Sorry, this cannot be the intendment of the provision. It will lead to severance of claims, unquote. In fact, more emphatically, the Court of Appeal, Pekwemujesi, held us in the case of UBA and others with Oladejo citation captured. As regards whether this court has jurisdiction in respect of malicious prosecution arising out of workplace, I quote, a painstaking perusal of the provision of section 254C1 of the 1999 Constitution of Nigeria seems to me that the provisions confers on the National Industrial Court jurisdiction over trade union and labor matters, employment law rules. It does not pertain to criminal matters or tort. Section 254C1B of the Constitution of the Federal Republic of Nigeria states relating to, connected with, or arising from Factories Act, Trade Disputes Act, Trade Union Act, Labor Act, Employees Compensation Act, or any other act or law relating to labor, employment, industrial relations, workplace, or any other enactment replacing the acts or laws. From above, it is indicative that the provision of section 254C1 of the Constitution only covers acts or laws mentioned in section 254C1B of the Constitution of the Federal Republic of Nigeria. These are matters arising from Factories Act, Trade Disputes Act, Trade Unions Act, Labor Act, Employees Compensation Act, or any act or law relating to labor, employment, and indeed industrial relations. That section of the Constitution does not pertain to malicious prosecution, assault, detainee, or any liability in tort. The infringement of a right of a person in his workplace is not enough to confer jurisdiction on the National Industrial Court, except where there is employment issue. The case of a respondent being one for malicious prosecution has nothing to do with respondent's condition of employment or contract of employment. The High Court of the State is the appropriate forum seized with the jurisdiction to entertain the action, unquote. The point must also be stated that it is clear from the decision of the Court of Appeal, Bisong and Unical Supra, and Akpan and Unical Supra, that a claim cannot be considered as ancillary to the main claim when it is completely removed from the subject matter of the main claim. And as such, a careful examination of the provisions of section 254C of the Constitution will not reveal that the powers of this court extend to entertaining a claim in tort at all. The court went further that a claim in tort cannot be considered as being ancillary to a claim for wrongful dismissal when brought before a court which has its jurisdiction limited by statute like this court. Consequently, the court maintained that a claim for defamation stands on its own. By the doctrine of stare decisis, this court is bound by the above decisions of the Court of Appeal as to the jurisdiction of this court to entertain claims in tort arising out of workplace, even when it feels otherwise. See the case of Nigeria Arab Bank Limited and Barry Engineering Nigeria Limited, citation captured. It is in light of the above that I find that the jurisdiction of this court is austed in respect of a tort of defamation, part of this claim, and as such, release 1, 4, 5, and 6 in the statement of facts, which are premised on the tort of defamation, are accordingly struck out. I so hold. It is the position of the claimants that they were employees of the defendants having been employed. The facts of the employment of the claimants are not in dispute in this case, considering the pleadings of parties. It is equally not in question that the employment relationship between parties is governed by the condition of service of the evangelical church winning all, the constitution and bylaws of the defendant. It is a settled position in our labor jurisprudence that there are basically 3 types of employment, namely purely master-servant, employment held at the pleasure of the employer, and employment with statutory flavor, which is also called employment protected by statute. See the case of Lunga and FBN PLC, citation captured, the case of Derima and River State Civil Service Commission, and the notorious case of Alani and Unilag, citation captured. It is a submission of Learned Counsel on behalf of claimants, be it paragraph 4.03b of the final address, that the employment of claimant is one with statutory flavor. Learned Counsel on behalf of the defendant by paragraph 6.4 of his final address was greatly opposed to this view. An employment is said to be with statutory flavor when it is protected by statute. See the case of Olorum Toba Ojo and Abdurrahim, citation captured. Idoni Boye Obu and NNPC, citation captured. In an employment that is purely of a master-servant nature relationship, usually governed and regulated by the terms and conditions agreed to by parties in the contract, the right and the manner in which the employment is to be brought to an end by way of termination, resignation, or dismissal are ordinarily spelled out in the terms and conditions of the contract. Since parties are added them, that the employment relationship is one governed by condition of service of the evangelical church winning all, the constitution and bylaws of the defendant. It is devoid of any statutory flavor, contrary to the assertion of Learned Counsel on behalf of the claimants. The position has remained settled that when an employee complains that his employment has been wrongfully terminated, the employee has the onus to place before the court the terms and conditions of the contract to prove in what manner the said contract were breached by the employer. See the case of Akpabio and Union Bank PLC, citation captured. The case of Union Bank and Salahuddin, citation captured. It is the position of claimants, be it paragraph 25 of their statement of facts, that they were purportedly dismissed since 2016, even though there is no instrument to that effect, and the procedure laid down by the condition of service were not complied with. They further stated that read paragraph 30 of the statement of fact that they were not issued with any query or given any form of hearing, and were not tried before the defendant purportedly dismissed them from employment and stopped their salaries. Without mincing words, the condition or terms of the contract of employment is the kernel and bedrock of the case founded wrongful or unlawful termination of employment. In fact, it is handbook law that parties are bound by the terms of their contract, and the duty of the court in such instance, where the terms of contract is laid before it, is to interpret the terms to reflect the intention of the parties and give effect to same. See the case of Sahara Energy Resources Limited and Uyebola, citation captured, Omega Bank Nigeria PLC and OBC Limited, citation provided. Tied to the above firm position of the law is equally the settled position of the law that where the words used in the contract are clear and not ambiguous, the words should be given their ordinary, simple, and grammatical and natural meaning. See the case of a said Petroleum Nigeria Limited and Petroleum Equalization Fund Management Board and another citation captured. The condition of service of the defendant is herein as Exhibit C4, and same will now captivate the attention of this court. Chapter 4 of the said condition of service contains specific provisions on discipline of an employee of the defendant. And for the sake of clarity, I will produce salient portions of the said provision. Quote, Section 17, basis for disciplinary proceedings. Disciplinary proceedings in accordance with this chapter are initiated because of the staff misconduct, inefficiency, and or redundancy. The discipline of church members who are not ECWA staff or in ECWA employment shall be in accordance with the ECWA Constitution and bylaws and the minister's hand. Section 18, authority and delegation. The power to discipline, interdict, suspend or dismiss or exercise any other disciplinary measures over all staff in ECWA service is vested in the department board/DCC or other bodies appointed by ECWA. 19, reporting misconduct. It shall be the duty of every staff to report any case of misconduct that comes to his notice to a staff superior to the staff involved. 2, when a staff misconduct is brought to the notice of his superior, it shall be the duty of that superior staff to report it to the head of department without delay. 3, on receiving the report, the head of department shall take action in accordance with Section 20 and if necessary, may recommend to the board or may himself order, if within powers delegated to him, the interdiction of the staff or at the appropriate point in the investigation, the staff may be indicted. 5, disciplinary proceedings shall be conducted in accordance with the provision of a relevant section. Section 20, procedure. Where there is allegation of misconduct against the staff under Section 19 and the head of department or board does not consider the alleged misconduct serious enough to warrant proceedings under Section 21, it may cause an investigation to be made into the matter in such manner as it considers proper, and the staff shall be entitled to know the whole allegation made against him and shall have an adequate opportunity throughout to make his defense. 2, if as a result of the investigation, the head of department or board finds that the allegation is proved, he may inflict such punishment upon the staff as by way of demotion, incremental penalty, or any other approved punishment. 21, dismissal of permanent staff. A permanent staff may be dismissed by the board in accordance with the following. 1, the staff shall be notified in writing by his head of department of the allegation against him, and he shall be called upon to state in writing any grounds upon which he relies to exculpate himself. 2, when the head of department is not satisfied with the grounds for which the staff relies, shall refer the matter to the board. 3, the matter shall be investigated by the appropriate committee as may be approved by the board. 4, no documentary evidence shall be used against the staff unless it's previously been supplied with a copy thereof or given access thereto. 5, the committee shall inform the staff of the date of his sitting, the allegation against him, and he shall be required to appear before it and defend himself, and shall be entitled to call witnesses. His failure to appear shall not validate the proceedings of the committee. 6, the staff does not furnish any representation within the time fixed. The committee may take such action as it deems appropriate against him. 7, the staff submits his representation and the committee is not satisfied after his sittings that he has exculpated himself, considers that the staff should be dismissed, he shall recommend his dismissal to the board. 8, upon considering the report of the committee, the board is of the opinion that the staff shall deserve to be dismissed, it shall direct accordingly. 9, upon considering the report of the committee, the board is of the opinion that the staff does not deserve to be dismissed from service, it shall impose any other punishments as it considers appropriate. 10, if during the course of the inquiry further allegations are disclosed and the board thinks fit to proceed against the staff upon such grounds, the staff by the direction of the board shall be furnished with a written statement thereof, and same steps shall be taken as prescribed in respect of the original grounds. 11, the board does not approve, where the board does not approve the staff dismissal and does not consider that any penalty should be imposed, the staff shall be reinstated forthwith and shall be entitled to full amount of salary denied him if he was interdicted. 12, if upon considering the report of the committee or panel, the head of department or board is of the opinion that the staff does not deserve to be dismissed, but the proceedings disclose grounds for requiring him to retire, the board shall without further proceedings direct accordingly. Effect of dismissal: a staff who is dismissed forfeit all claims, including retiring benefits, gratuity, and pensions. 27, effective date of dismissal: when the staff is dismissed, no notice of salary in lieu of notice shall be given to him. Termination of employment: acts leading to queries or warnings. Act which could attract queries or warnings are as follows: absence from duty without permission, sleeping while on duty, negligence of duty, insubordination, making false statement in particular matters, or failure to disclose relevant information, behaving in a way that constitutes a public nuisance or put ECWA in disrepute, incompetence or inefficiency. Acts leading to dismissal: any ECWA staff or suspension shall be on half salary. The following acts may lead to a staff termination or dismissal: drinking alcohol drinks, taking illegal drugs, false claims against ECWA, falsification or suppression of records, dishonesty, engaging in partisan politics without permission, unauthorized publication, talking to press or writing anonymous letters, unauthorized disclosure of official information to the persons not entitled to such information, fornication, adultery, lack of declining productivity, disloyalty or disobedience to ECWA leadership and ministry, any other act of misconduct which may warrant a suspension as incompatible with ECWA articles of faith and practice, ECWA constitution and bylaws, ECWA condition of service, ECWA ministers handbook, ECWA financial policies and guidelines, and general church council resolution. M, engaging in professional private practice, and polygamy, polyandry, divorce and remarriage contrary to ECWA guidelines, conviction for criminal offense or other than traffic offense or the like. P, fraud, embezzlement, misappropriation, mismanagement of funds, and theft, unquote. The above provision of the condition of service is clear and comprehensible. As such, it requires no special aid to understand. The disciplinary procedure for dismissal is as captured in Section 21 of the said condition of service, which provides for dismissal of a permanent staff. The pertinent question here is, are the claimants permanent staff of the defendant? By the provision of Section 8 of the condition of service, there are three different types of appointment in the defendant, namely short-term contract, permanent appointment, and contract appointment. The short-term appointment is for a maximum period of 6 months, while the permanent appointment is a pensionable type of employment, and the contract appointment is an appointment for a duration of 2 years, renewable for a period not exceeding 2 years. Claimant in this case averred that the employment were confirmed by the defendant by paragraph 9 of their statement of fact. This was not specifically denied by the defendant in its paragraph 9 in its statement of defense. The claimants, according to the facts averred in their pleadings, were employed by the defendant in the years 1992, 94, and 2004, and their employment was confirmed 2 years later by the defendant. See paragraphs 1, 2, and 3 of the statement of facts. This fact were admitted by the defendant in his statement of defense. See paragraphs 4 and 5 of the statement of defense. It is true that the burden on the claimant is not to prove every fact he relies on, but to prove only those facts that are put in issue by the defendant, because facts admitted needs no further proof. See the case of Akande and Adisa citation captured, Bunge versus Governor of Rivers State citation provided. In view of the above, it is thus clear beyond argument that claimants are permanent staff of the defendant, to which Section 21 of the condition of service applies. By the provision of Section 28(2)J and M of the condition of service, disloyalty or disobedience of ECWA leadership and ministry and misappropriation of funds could lead to dismissal, which are the offenses claimants were alleged of in this case. By the provision of Section 21 of the condition of service, the first step in the dismissal of a permanent staff of the defendant is by issuance of query, requesting such an employee to make written representation. As reason supra, it is the claimant's contention that they were not given query or allowed to make representation concerning the issue leveled against them. See paragraph 30 of the statement of fact. The defendant in this case has pleaded several query letters given to claimants in the year 2014, which were front-loaded on record. I peruse all these queries purportedly issued to claimants, and I find a common trend in all of them and that is the absence of a query by the claimants, particularly queries dated 13th August 2014 and 10th September 2014, which are pivotal to the dispute in this case. Ordinarily, where it is alleged that the document was delivered to a person who denies receiving such document, proof of delivery of such persons on such persons can be established by any There was an interlude, so I continue from there. I was, yeah, let me see. I was citing some cases in support of the fact that proof of service of documents should be through dispatch book, evidence of dispatch by registered post, or evidence of witness credible enough. Then I cited O'Malley and Federal Polytechnic and another, the case of registered trustees of the Apostles Church versus Mrs. Olufemi Fatude, the case of Inlewe Dim and Uduma citation captured. There's no evidence before this court, whether by way of dispatch book, evidence of dispatch by registered post, or evidence of credible witness, or evidence of acknowledgement of receipt showing that any of the claimants was served with any of those several queries. It is therefore difficult to believe that any of the claimant was served with any of those queries at all in view of the scars of evidence in proof of same. I'm mindful of a submission of learned counsel on behalf of the defendant, Chief Tunji Ologmoyo Esquire, on issue 5, that the claimants were aware of the query letters and transfer letters going by the content of paragraph 1 in SVC 9. I perused the said SVC 9 with particular attention to paragraph 1. I must first state that the said exhibit was not written by any of the claimants or by the Central Planning Committee and signed by one elder SM Uloge and learned defense counsel Chief Ologmoyo. It is the law that a person is only bound by the contents of a document which he has signed or executed. See the case of Nwari and Daniel Adakwa citation captured, Adefarasi and Dayak citation provided. Thus, the said SVC C9, having not been signed by any of the claimants but by learned defense counsel and another person, cannot be interpreted against claimants. Besides, the query which Exhibit C9 in paragraph 1 stated to have been delivered to some selected ministers is one dated 13th of August 2014. First, the name of those selected ministers were not mentioned in the said letter. Besides, the said Exhibit C9 clearly states it in its heading that it is in response to query letters for failure to attend meetings and non-remittance of statutory dues, and which query purport to be the one dated 13th August 2014. The query letters which were front-loaded by the defendant in this case is not just one dated 13th August 2014. There are orders alleged to have been written to each of the claimants dated 9th and 10th of September 2014, which, as reason supra, has not been shown to have been served on claimants. Thus, the submission of learned counsel will not avail the defendant to prove the service of the several queries on the claimants. It is equally clear from the above provisions that the allegation against the staff shall be investigated by a committee as may be approved by the board, which committee shall give the officer affected the notice of its meeting. The defendant, read paragraph 25, averred of their defense, averred that upon claimant refusal to proceed on transfer, they were invited by the defendant so that they would be able to make representations on the matter through DCC, read the letter dated May 15, 2015, and which invitation was communicated to claimants by DCC by a letter dated 21st of May 2015 and others through DHL, but they refused to accept the said letter going by DHL report. Claimants, by paragraph 8 of their reply to statement of defense, averred, among other things, that they were never served with any transfer letters, warning letters, and were never invited to any meeting for reconciliation, and no attempt was made to serve any letter through DHL. Through DHL. The position of the law has remained unshaken that the burden of proving a particular fact is on the party asserting same. See the case of G&T Investment Limited and Wheat and Bush Limited citation captured. The burden is clearly on the defendant to prove that the letter requesting claimants to show cause while disciplinary action should not be taken against them or sent to claimant by DHL, and they refuse to accept the same as asserted by it. The defendant, in my humble view, have failed to discharge this burden because from the documents concluded with this court is to rely on, in virtue of the special procedure in this case, there is nothing to show that the letter was even sent by DHL. In the first place, whether by way of receipt of payment for the courier service, neither is there a report of DHL office showing that they attempted to serve the letters dated 21st of May 2015 on the claimant, but they were rejected. In the absence of such evidence showing that the letters were sent through DHL and that claimants upon it being served refused to accept same, this court does not believe same. The apex court in the case of Inlewedim and Uduma Supra held thus per Begorigi CCJN9 retired as regards the probative value of a document which has not been proven to have been served on the other party as follows, I quote, "The law is clear as to admissibility of such a contentious document in the face of a denial of having received it by the defendant. The procedure for tendering of such document is after the statement of defense had clearly traversed the averment of having sent it to the defendant, and in the absence of a dispatch book indicating its receipt or evidence of having sent it by registered post, the probative value of such documents will be worthless unless there are witnesses credible enough to testify that the defendant was served with it," unquote. It is in the light of this that I find the said letters dated 21st May 2015 worthless and of no probative value in this case. I so hold. In fact, from the fact and circumstances of this case, there is no evidence that any of the above steps was followed by the defendant in the purported dismissal of claimants. There is therefore no doubt that the provisions of the condition of service were not complied with in the dismissal of the claimants. However, it is so apparent from the circumstances and facts of this case that the relationship between the parties had gone sour and was severed wrongfully. The claimants cannot deny the fact that they were no longer wanted in the employ of the defendant. In fact, by the averments in paragraph 25, 11 to 12 of the statement of facts, the letter of dismissal of the claimants herein were not handed to them, but was published in the National Daily, that is Nigerian Tribune of 14 January 2016, and the publication, which publication the claimant issued rejoinder to, and the same paper of 21st of January 2016. These facts were not categorically denied by claimants in paragraph 8 of their reply to the statement of defense. In my view, claimants admitted this much when in their statement of facts admitted the notice of disclaimer published by the defendant on 14 January The fact that the contract was not determined according to the dictate of the condition of service does not ipso facto mean it was not determined, albeit wrongly. See the case of Keystone Bank Limited and Clark, citation captured. The court per NIMPA JCA in the case of Keystone Bank and Clark Supra held inter alia those, and I quote, it is settled that where the employment is wrongfully terminated, the employee is entitled to salary and entitlements over the period of notice, in this case, 1 month. It is certain that once an employer takes steps to terminate a contract wrongfully, the contract still remains terminated. The court cannot find otherwise. It is wrongful action of the appellant that gave the respondent the cause of action. It is contradictory for the respondent to assert he is still in the employment of the appellant and still claims the release he did before the trial court, unquote. It is thus clear that from the moment an employer mulled over an intention to disengage an employee in a master-servant employment and expresses such intention, albeit wrongly, the employment stands terminated from that date and such dismissal cannot be declared null and void. The Apex Court per Guagu JSC in the case of Oshisanya and Afribank Nigeria PLC held those, and I quote, it need be stressed, and this has long been settled, that a master and servant relationship, a dismissal of an employee by the employer cannot be declared null and void and of no effect whatsoever. The remedy is, as is settled, is an award of damages where the termination or dismissal held to be wrongful, unquote. The remedy only lies in damages. This is simply because the court cannot force the willing employee on an unwilling employer. See the cases of Nigeria Bottling Company Limited and Idowu, Olariwaju and Afribank Nigeria PLC, citation captured, Chukuma and Shell Petroleum Development Company of Nigeria Limited, citation captured. Thus, Relief 2 succeeds only to the extent that the dismissal of the claimant is wrongful for being in contravention of a condition of service, while Relief 3 in the statement of facts must fail. I so find and hold. Now, regarding claimants' claims for salaries from the year 2014 to 2021, claimants by Relief 7 claims for the sum of 8,904,227 naira, 11,146,161 naira, and 6,275,684 naira, respectively, as their salaries from the year 2014 to 2021. Monetary claims are in the realm of special damages, and the law has been settled in plethora of cases that a claim for special damages must be specifically pleaded with distinct particularity and strictly proved. Put differently, the full particulars of the items have to be given in the pleadings, and evidence led in proof of each item or each of the particulars of the item or items given. See the case of Ene on Ozo, citation captured, Agi and Access Bank PLC, citation provided. First, let's state that claimants cannot claim for salaries beyond 2016 when they were dismissed from the employment of the defendant, albeit wrongfully. The claimants cannot choose to still treat the employment as still subsisting and claim for salaries beyond the period of termination or dismissal, as I've stated earlier. This is because a dismissed worker cannot claim for salary for work not done. See the case of Balogma Union Bank, citation captured. In the instant case, claimants can claim for salaries only up to the period of dismissal. They cannot claim for salaries beyond this period. As such, claimants can only claim for salaries from 2014 to January 2016 when their employment was severed, albeit wrongfully. I so find and hold. Claimant by paragraph 31 of the statement of fact averred that from the moment they craved for and demanded the establishment of a new district church council, the defendants stopped paying their salaries. They particularized their claims in respect of the monetary sums claimed, be it paragraph 32 of the statement of facts. The defendant in response, be it paragraphs 28 to 32, averred that claimants are not entitled to be paid salaries because they have refused to remit the statutory payments that by section 98 of the defendant's bylaws payment of salaries and emoluments of its pastors are paid by the churches under which they were served through annual assessment of what the pastor is expected to receive for the year from the district church council. It maintained that the churches under claimants have refused to remit any statutory dues, and no money has been remitted to MOPA or KABA-DCC for the payment of the assessment levied for payment of pastors' salaries, and will lead to issuance of queries dated 13th of August 2014 and that of 10th of September 2014, respectively. It maintained that claimants since April 2014 have not been having any fellowship with any of the defendants' MOPA-DCC. Claimants, in response by paragraph 10 of the reply to the statement of defense, averred that it is the defendant that was paying the salaries, emoluments of claimants and all pastors in ECWA. An issue of remittance of money is to be taken up with the elders of the church, not claimants. From the state of pleadings, it is clear that the defendant did not pay the claimants as averred, but its only excuse is as stated supra, that claimants failed to remit statutory dues, and that by section 98 of the of their bylaws, the salaries of claimants are to be paid by the church under which they serve. I've gone through the provisions of section 98 of the bylaws, which is before this court, and I find that by the said bylaw, the local churches are to be responsible for remuneration of pastors. However, the said bylaw is said to be amended. It's said to be amended 2019, while the dispute in this case arose before the said 2019. In fact, the claimants have been wrongfully dismissed since 2016. Thus, the bylaws dated 2019 is of no evidential value to this case. Only the one which was enforced during the period of the dispute in this case can be of evidential value. And I'm, however, mindful of the fact that from the contents of the queries purportedly written to be given to claimants dated 10th September 2014, which the defendant front-loaded in this case, and which the court have held that they were not served on the claimants, the failure to release or remit statutory dues seems not to be the fault of any pastor, but that of elders. I say so in view of paragraph 2 in the said queries, which read those, and I quote, "Why you showed a nonchalant attitude as an ECWA pastor by refusing to report to the DCC office about the negative reaction of your elders as regards their refusal to release the statutory dues for payment to the DCC office, and also disallowing you from attending DCC/ECWA approved meetings, but instead attend other unconstitutional meetings," unquote. Also, lending credence to the above, that it was the elders that refused to release the statutory dues and all the claimant is the content of SBC 9, which is a letter written by Central Planning Committee as reason supra, was signed by learned counsel on behalf of the defendant. Therein, particularly in the 4th paragraph of the said SBC 9, was clearly stated, thus, I quote, "It is quite clear that from the decisions at the meeting of the elders and fellowship leaders of each LCB in the 6 LCCs of the proposed KABA-DCC of 13th April 2014, that no minister of God from the proposed DCC will attend any meeting with you, nor remit any so-called statutory dues to you until further notice. The decision was properly conveyed to you in very clear details in our letter dated the same day," unquote. It is clear as crystal from the above that even the defendant knew that the non-remittance of statutory dues was not any fault of the claimants, but the decision of the elders of the church. Therefore, it cannot be said that the claimants were not entitled to be paid because they failed to remit statutory dues. Defendant ought to have taken that up with the elders of the church and not met out punishment on the claimants. Howbeit, an employee is entitled to be paid salaries and allowances for the period of his lawful engagement. See the case of Mwafo and Anambra State Education Commissions and other citation captured. The defendant herein have not said that claimants have not worked in their capacity as pastors in their churches till they were dismissed. It merely averred by paragraph 32 of the statement of defense that since April 2014, claimants have not fellowshipped with any of the defendants' Mokwa District Church Council or any of his district church council. It is a fact of notorious knowledge, of which this court shall take judicial notice of, that in Christian faith, the basic duty of a pastor is to preside over a pastor. The defendant has not stated that claimants have not performed the work of a pastor in their respective churches since 2014. In fact, letters of transfer which were concluded by the defendant were only written on 23rd of December 2014, purporting to transfer claimants from their several places of assignment to different places of assignment, which is an indication that claimants worked till that day. Just as with other letters in this case, there's nothing on the said letters to even show any of the claimants were served with these letters of transfer, and the subsequent letters written as reminders dated 7th of April 2015. In fact, Section 30 of the Condition of Service clearly states that where a minister in charge of the church is placed under church discipline, he shall vacate the pastorium and be placed on half of his basic salary for the period of discipline. Thus, even if the discipline of claimant had been conducted properly, they will still be entitled to half of their basic salary for the period of discipline. As such, there's nothing under the condition of service to warrant them not being paid at all, as was done in this case. Notwithstanding the above, it is still the duty of claimants to strictly prove with distinct particularity the sum they claim as salaries from 2014 to 2016 when they were dismissed being special damages. Claimants in this case merely gave a blanket particularization of the annual salaries of each of the claimant for each of these years. They did not in any paragraph plead how much each of them was entitled as monthly salary in each of these years, particularly where they are claiming different amounts as annual salaries for each of these years. They equally did not place any evidence before the court to show how much each of the claimant was entitled to per month for each of those years, as I've stated earlier. It is not sufficient to particularize the claim of special damages as was done by claimants in this case. Evidence must as of necessity be led to prove the particulars of the claim. The onus of proof rests squarely on the claimants. It will not shift to the defendant, and it has to be strictly discharged by claimants in this case. See the case of Better Glass PLC and Ekpaku Holdings Limited citation capture. I find that claimants have failed to discharge this burden, leading evidence in support of the sums claimed from 2014 to when their employment was severed in January 2016, notwithstanding the court have found that they are entitled to be paid till when they were dismissed from the service of the defendant. Therefore, failure to call evidence in support of the said sums claim from 2014 to 2016 is fatal to their claims for special damages. See the case of Yalaju and others of Zadidi and others citation captured. In view of all reasons, supra, relief 7 is bound to fail and is thus dismissed. In the light of the above reasoning, I find that claimant's claim succeeds in part, and I declare an order as follows for the sake of clarity. 1. Reliefs 1, 4, 5, 6 are struck out for being in want of jurisdiction, that the dismissal of the claimant is wrongful for being in contravention of a condition of service. Reliefs 3 and 7 fail. Parties are to bear their respective costs. Judgment is accordingly entered.
Good.
Copies of the judgment will be forwarded to you in Lokoja. I'm suspecting you were the one that drafted the condition of service. And you did it as if it was a statutory employment. No wonder the claimant counsel says it's a statutory employment.
My Lord, we want to commend your Lordship.
Very well. Like I
For the
said, a
considered
copy of the very well. A copy of the judgment will be forwarded to you in Lokoja. So I rise from Lokoja.